Durable powers of attorney. Have you ever thought about what would happen if you became unable to make your own decisions, perhaps because of illness or medical condition, such as a stroke or a coma? Using a relatively simple legal document, known as a durable power of attorney, you can legally empower another person, such as a trusted relative or friend, to act in your behalf, even if you became physically or mentally unable to manage your own affairs. You'll also likely avoid the need to go to court to have someone appointed as your guardian or conservator. Powers of attorney come in a variety of flavors, so make sure you use the right type for your needs. They generally enable the person or persons you designate to take the actions you authorize them to do, as broad or narrow as you choose. You may give permission for them to manage your bank accounts and write checks for you, pay your bills and rent, manage your investment accounts, enter into contracts dealing with insurance claims, operate your business, and buying and selling real estate. A standard power of attorney may make sense if you're going on vacation or going away on business or military service. If you need someone locally to sign the deed on that house you've been trying to sell or settle that insurance claim, a standard power of attorney is just fine. However, unless the power of attorney is durable, it becomes invalid when you may most need it. A durable power of attorney remains valid, regardless of mental or physical impairment, until you revoke it or it expires after a period of years set out in your state's law. Although the document is called a power of attorney, the person you designate need not be an attorney, and usually is not. He or she becomes your agent with full power to act on your behalf. Giving someone else a power of attorney does not mean that you can no longer make your own decisions. You have full power to make your own decisions. It does mean that the other person will also have the power to take action for you. If you feel uncomfortable giving anyone else broad power to act for you, and you want to restrict their power to act to the circumstances when you become mentally or physically incapable of acting, you can do that. Instead of signing a broad, immediate, durable power of attorney, you'll want something known as a springing durable power of attorney. It springs to life only when the specified conditions occur, such as your loss of mental or physical ability to act, perhaps as certified by your doctor, or perhaps if you're taken captive by pirates in Somalia. You can revoke a power of attorney at any time by telling the agent you designated that you've canceled or revoked the power. To be extra safe, you should also request that the original copy of the power of attorney be sent back from the agent. Powers of attorney typically remain valid during your lifetime until the earlier of the date you revoke it, or about 5 to 7 years, all depending on your state's law. Now, upon your death, all powers of attorney you've given immediately become invalid, because after your death, the terms of your will or your state's laws of intestate succession typically control the management and distribution of your property. There's lots more information on this and 100 other legal topics on freeadvice.com, with additional videos, easy-to-understand lawyer-prepared articles and FAQs, the Free Advice forums, and the Ask a Lawyer service. Looking for an attorney? AttorneyPages.com is the place to start.